incidental or ancillary to any matter can also be brought in. Now, what does this expression mean? Entry 55, there can only be enlargement of jurisdiction, but only where there is an express authorization by or under the Constitution.
But you're missing out the earlier words, as is expressly authorized by or under the Constitution.
Yes.
No, just wait a minute.
Well,
where is 184.3 expressly authorized?
it is not.
It is. 184.3 is in the Constitution.
But there is...
You're not hearing the point. देखिए, extent as is expressly authorized by or under the Constitution. 184 पार तो हमें दिया हुआ है ना आइन ने. हमें बस खुद से तो नहीं आया ना. दिया हुआ है आइन ने. ठीक है? Enlargement of the jurisdiction of the Supreme Court. Now the question is that 184.3 power that is already given to us. The Constitution could have not given that power to us. It is not an inherent power of the nature as under Section 9 of the Civil Procedure Code. Correct?
My lord.
It's an extraordinary power which is rarely given in any constitution in the world.
Correct, man.
Correct? So far we are good.
Correct.
So that power was given by the Constitution to us. Now, are they giving an appellate forum therein, enlarging the power or taking away the power?
My lord, twofold answer. They are taking away the power.
How?
By, and I rely on the judgment which...
तो judgments को छोड़िए ना, आप arguments दीजिए ना अपने.
मैं सपोर्ट कर मैं arguments precedent की बेस पे दूंगा.
आप अपने हम no contention note कर लेंगे आपके.
मतलब it is a curtailment of power because the concept of finality that attaches to judgments under Article 184.3
but that's a different concept. देखिए, for instance, a three-member bench decides something. Naturally, a three-member bench cannot undo it. Five-member bench हो गई है, whatever, full court हो गया. तो 184.3 की उन्होंने enlarge कर दिया power. ठीक है? I'm trying to wrap my head around the fact that you keep saying that it's taking away the power. The first power was conferred by Parliament through the Constitution. That power is being enlarged. If this power was given to, for instance, the Senate of Pakistan, okay, you will sit in appeal over 184.3 because Supreme Court can't sit in appeal over its own orders. So then maybe, yes, you're absolutely correct. But this power, it has not gone out of this building. It remains within the building. And unless you say two minds are always better than five, that ends the story. But, you know, so you're saying that more minds would actually be destructive of the 184 inherent power if they think about something, or with the passage of time they may want to revisit things or maybe want to appeal things. I mean, you don't know. One thing is, of course, you can revisit something. ठीक है, वो तो एक अलग बात हो जाती है. वो तो revisit आप करते रहें. फिर वो देखें number of the judges count होगा, ये होगा, वगैरह होगा. बट ये तो एक स्पेसिफिक पावर दिया रहा है. इसमें मुझे समझ नहीं आ रही है मेरे पावर क्या सुप्रीम मेरे तो पावर्स कम हो रहे हैं, सुप्रीम कोर्ट के पावर्स बढ़ रहे हैं. तो इसमें आप कैसे कह रहे हैं कि कम हो रहे हैं, ये जरा समझाइए मुझे.
My lord, as I said, I am as a counsel of this court bound by the law that your lordships lay down in precedents.
Sorry to say, this is, आप मुझे कोई चीज बता दें. You as a counsel are first and foremost bound by the Constitution of Pakistan and the laws of Pakistan. फिर उसके बाद प्रेसिडेंट आएगा. प्रेसिडेंट आप लोग सब पहले रख देते हैं आइन और उसको छोड़ दीजिए, वो बाद में आता है. पहले आएगा आइन, फिर आएगा लॉ, फिर आएगा प्रेसिडेंट. ठीक है? सुप्रीम कोर्ट्स, if they've been making laws, I think that's wrong. Their power is to interpret law. If a law violates some constitutional provision, strike it down. Now, we cannot assume power. I have not taken an oath to uphold the judgments of the Supreme Court. I've taken an oath to uphold the Constitution and the law of Pakistan until such time that law, I feel, is violative of a fundamental or whatever you want to argue, even the whole scheme of legislative scheme that has been laid out. I'm not bound by precedents. If that was the case, I would not have taken oath even as a judge. If I'm bound by all the precedents of the even dissent, even if the whole court says, I can still maintain I don't agree, but it will still be binding on me. That's a different thing. 189 says it will still be binding on me, but I can say I disagree. Otherwise, you kill dissent also. Then everybody has to agree to everything else. So don't just. These are important questions. You're just sort of saying that your powers have been taken away. I don't feel they've been taken away.
Before you, if you could explain the entry 55 again, I haven't got. General, उसमें बता दें.
entry 55 allows, number one, only the enlargement of jurisdiction of the Supreme Court.
Ji.
And only where there is express authorization to that effect in the Constitution, by the Constitution or under the Constitution. These are the three conditions.
Enlargement का क्या मतलब है? How do you understand enlargement?
Enlargement, for me, as a matter of plain English, means something exists and you make it bigger. As, again, my lord, with all
Doesn't it destroy your argument?
my lord, let me
जी, जी,
articulate.
करें.
The word enlargement, what enlargement means in the context of entry 55, and what enlargement means in the context of entry 55 has been interpreted by this honorable court.
Learned Counsel, जरा मेरे समझने के लिए, there can be two situations. One, 184(3) ना होता और सिर्फ एक अपील दे दी जाती. Now here, 184(3) jurisdiction already exists. A remedy is being provided. So there's a distinction between these two situations. The jurisdiction already exists.
My lord, I'll come to that.
An appeal is a substantive right. It has to be substantively given by substantive provision in the Act or the Constitution. You cannot by implication or by rules or by subordinate legislation create a right. 184(3) is a jurisdiction in itself, the original jurisdiction. For 50 years it has existed as such. Why do you think even the dictators or even the legislative assemblies which amended the Constitution did not legislate on the one hand or amend the Constitution on the other, and why has it all of a sudden now been done, under what circumstances?
Yeah, Learned Counsel, Learned Counsel, I think there's a...
Mr. Bandari, you are in a very unenviable position.
Learned Counsel,
I sympathize with you. I sympathize.
I can assure that many of your lordship's questions might be answered, and I can't say will be answered, only if I'm allowed to articulate my
Learned Counsel, I think...
I can assure, my lord, if your lordship will just allow me to articulate my submissions.
बहुत अच्छा question इन्होंने raise किया है. I think that is also to be seen in historical context. There were only two judgments of this court after this constitution was promulgated: Darshan Mercy case and Benazir Bhutto's case. Regrettably, this court, after 2010, departed from both those judgments. And the manner in which 184(3) in many cases was used, that probably is one reason why the parliament, a representative body, wanted or intended to have these remedies.
My lord,
If you can go back to entry 55.
I'll go back to entry 55, but just as a brief riposte to that, my lord, two wrongs don't make a right. If this court was wrong, then the parliament is wrong now, and two wrongs will not make a right. And I'll come back to that. My lord, I'll come back to that. Let me go back to entry 55.
So going back to entry 55, can I be your voice on the bench
My
and
lord,
help you?
I'll be so grateful.
So what I'm trying to say is, just to support you and so that nobody sort of... So what you're trying to say is that entry 55 says that there has to be express authorization from within the Constitution for enlargement of jurisdiction. And one prime example, just as Asha had asked a question, prime example is 185(3), which says specifically that you can enlarge the monetary jurisdiction of the Supreme Court. So that is the express provision mentioned. Isn't that the case?
My lord.
So my question then is that if this is what you're saying that it is purely there has to be express provision in the Constitution. You don't understand the under the Constitution, but anyway, let's stick to the by the Constitution. And example would be 185, and perhaps there are some other provisions which would give that express.
I'll come to that.
But my problem with this is that when we talk about enhancement of jurisdiction, I see that, but I have a problem with the practice and procedure part. That practice and procedure doesn't really flow out of 55. And that kind of makes the word law then redundant in 191, because that law is not finding any support. Even if we say 191 is not enabling provision, then that law must stand alone, must draw some power from the competence from some source. It's not coming out of 55 because it is purely for enlargement of jurisdiction.
Well, it will come, if 55 is rightly invoked, then practice and procedure will come in through entry 59. That, my Lord, the Chief
No,
Justice.
but 59 reads that it has to be read along with the substantive part
Yes.
of it, which is enhancement of jurisdiction. So
Yes.
enhancement of
Let me give
jurisdiction
you-
is related.
Well, let me give you, there are, to my humble knowledge, there used to be one provision, was Zain Wali Constitution dena, regarding enlargement of jurisdiction, and which was actually taken notice of by this court in Baz Muhammad Kakar's case. This was, my Lord, before its repeal, this was Article 247, Clause 7.
इसका
Of the
पेज
Constitution.
970 पे पढ़िए ना जरा
जी।
ये पैराग्राफ पढ़ दीजिए इसमें बहुत सारी चीजें बाज मोहम्मद काकड़ वाले केस के अंदर हैं
जी।
पेज 970 पे पढ़िए एज इट हैज बीन पॉइंटेड आउट इसमें तो इन्होंने सपोर्ट किया है कि जो है जुरिसडिक्शन को बढ़ाना हो सप्लीमेंटल करना हो तो कर सकती है पार्लियामेंट
वो रिपील हो गया ना 247 जो
नहीं, आप कौन सा कह
तो
रहे
हो गया बट द जजमेंट इज देयर सुप्रीम कोर्ट का अपना जजमेंट तो है ना वो रिपील
हैं? Para 37 of Baz Muhammad Kakar. If I can just read this out, Article 247, Clause 7. As
पेज
now it's
कौन सा
been,
पढ़ रहे हैं पेज?
well, this is the Constitution itself. This was prior to its repeal.
नो
by the-
अब्बास मोहम्मद काकड़ का पेज कौन सा?
Page 967, Para 37.
Citation.
This is PLD 2012 Supreme Court, 923, Para 37 at 967. This is one example of enlargement of jurisdiction of the Supreme Court in terms of Article 247, Clause 7, which read, my Lord, neither the Supreme Court nor a High Court shall exercise any jurisdiction under the Constitution in relation to a tribal area unless Majlis-e-Shura, Parliament by law otherwise provides. And pursuant to this, an act was promulgated in 1973. And this was taken notice of by this honorable court in. My Lord, that's one example. The other is, as your Lordship mentioned, Article 185 of the Constitution.
185.3 is very
185 2 D and E.
2, 3, huh. Sorry.
These are